Welcome back to Law and Crime. I'm Judge Ashley Wilcott. Joining you here today as we cover 3 trials live, as well as the Smollett. There's a lot going on today. Let's talk about, we're going to go right now back to live trial. This is in the Kentucky versus David Dooley case. We're listening to testimony now. Let's rejoin and see where we are. So this is the cross-examination of Detective Brian Cochran. I'd like to bring in my 2 guests. Thank you both for joining me. Gene Rossi, criminal defense attorney, former prosecutor, and also Andrew Cherkasky, who was also a former prosecutor, now criminal defense attorney. Thank you both for joining us today.
Good morning.
Good afternoon.
Good afternoon. So, Gene, let me start with you. One of the things that this detective has testified to is that they did test the victim's blouse and jeans for fingerprints and DNA, and they did not find any on either. What does that mean?
Well, if they didn't find any DNA of the defendant, that's very good circumstantial evidence that points towards innocence. If they found DNA, then that would have been very bad facts, and it would be hard to overcome.
And so let me ask you, Andrew, what's the argument that has to do with the fact that the prosecution said, hey, listen, the defendant in this case, a janitor in the facility building where she was found, had jeans on, and they had a pocket ripped on the jeans. There was no blood, but hey, there's also a time period unaccounted for. How would you use that, defend that as the defense?
Well, when you're on the defense side, I mean, you look for whatever information you can to use to your advantage. Now, the absence of evidence or the absence of explanation of time doesn't necessarily mean that the crime didn't occur. But as a defense attorney, you've got to hone in on the idea of proof beyond a reasonable doubt. So when you have missing evidence or missing time and the prosecution can't explain it, that's great defense evidence.
And so, Andrew, is that reasonable doubt in and of itself, the fact that his pants, they did test for blood, no blood on his pants? The only thing they noted was a rip. Do you think that's enough to create reasonable doubt in the minds of the jury?
Well, it's something I would certainly hone in on if I was the defense counsel, but I think any defense attorney would be making a mistake to say that just one piece of missing evidence is going to be enough to create reasonable doubt. You've got to work with what you have, but you can't rest on just one thing. So in this case, it might end up being the piece that a jury member comes back and saying that's what created reasonable doubt. But as the defense attorney, you've got to work with whatever you can.
But listen, I think you've just made a really valid point, and that is not only did he not have blood on his pants, there's no DNA from the defendant on the victim's clothes. There was also testimony that time cards were found on the scene where the body was found with blood fingerprints. They did not match any of those fingerprints to the defendant. So put all that together, Gene Rossi, and tell me this. Why would the defense, knowing all of that information in the opening, say, oh, wait, wrong person, it was her husband who committed this crime? Why would they point to a specific person?
Well, if they put, what I gather here is they have evidence that he did work there as a janitor, but the circumstances of the death do not suggest that he was there at the time of the murder. And it kind of points towards, I guess, Dan, who said he was sleeping and he got $1 million in insurance proceeds. It kind of points towards him. I will say this. If you have a horrific crime scene and the defendant is the one who has allegedly committed the crime, you are going to have something on that victim or something near the crime scene, either DNA or prints, that connect the defendant to the crime scene. And I think that's pretty good evidence to raise reasonable doubt, depending on the jury.
All right. So, gentlemen, stay with me. We're going to return to court again. This is cross-examination of Detective Cochran, who's describing and has described on direct all of the evidence he found at the scene. Welcome back to Law and Crime. So here's what we're going to do with my legal analyst to talk about more of this testimony. Gentlemen, I have to tell you from the onset, I felt like, you know, all of the factors together, I'm worrying there's going to be reasonable doubt. I'm not worrying in terms of there should be a conviction, worrying in terms of, is the evidence clear against this defendant to have this defendant on trial again, knowing that he'd been convicted one time, overturned, he's back in trial. So let's talk a little bit, Andrew, I'd like to start with you about the actual crime scene. We've seen the overhead videos. It's a huge warehouse, a very big area. There's a lot going on at the crime scene. How much does that affect the ability for the best of law enforcement to collect evidence to be able to tie the defendant to the crime of murder?
Well, one of the things that I think you have to keep in mind is that this is an old case. It's almost 10 years old, the first conviction being in, I believe, 2012. So the idea that you have an exaggerated sense of what sort of forensic evidence you're looking for with jurors today than perhaps at the original trial. So when you have such a large crime scene, those investigators perhaps 10 years ago, 10 plus years ago, weren't looking with the same degree of acuteness that investigators would be looking for today, because I think jurors expect more today.
And I think that the detective in this case has done a really great job. I think he's very credible, very personable. He's pulling out of the bags, you know, all of the pieces of evidence he's testified to. Gene, tell me about the jury's reaction when they get to watch the bag get opened, the evidence come out. I think that's something that has them enthralled, and they're going to see the actual evidence. How does it impact a jury in your experience?
Oh, God, I have so many stories of where the crime scene detective or officer has the bags of evidence, whatever it is, and especially drugs, and the jury is enthralled. They watch television, but they never see it in person. So they don't know what a heat seal is. They don't know what a chain of custody is. And Andrew brought up a very good point. In 2012, you know, the whole CSI syndrome, which you now get a jury instruction on, saying we don't have to prove certain CSI requirements. Andrew hit the nail on the head. In 2012, they probably didn't do as thorough a job versus what they would do today. And the large area, you know, actually helps the defense versus a small car. But going back to your question, I've seen jurors literally get on the edge of their seat, tilting their head, trying to get a closer look at the actual evidence, and then the judge sees that and said, hey, would you like to hold it? And then you give it to the jury, and that's a prosecutor's dream when they touch evidence, not contaminated.
Hey everybody, I'm Jesse Weber. Hey everybody, I'm Jesse.
I completely agree with you. We're going to have to go to a short break, but you're going to want to come back because these two legal analysts are excellent as we covered the Dooley trial. Also, Jesse Smollett, you've been hearing about what's going on. We are going to have a special here from 2 to 2:30 with experts on our panel discussing and analyzing and giving you the current breaking news in that case. You won't want to miss that at 2 o'clock today. Come back and tune in right after this break. We'll return to the Dooley trial. All right, so again, that's the Dooley case. They are at a sidebar, and I'd like to bring back in my legal analysts today, Gene Rossi and Andrew Cherkasky. Did I get that correct, Andrew? I want to make sure I pronounced it right.
You got it. Thank you so much.
Fantastic. So, gentlemen, let's talk about this in this case. As you both know, this defendant was convicted, and it was actually in 2014. He had a trial, convicted, and then we learned made-for-TV movie. Yes, the district attorney was having an affair with the lead investigator, and it was brought out that there was surveillance not provided, and there was an unknown man entering the workplace, the building where this woman was found murdered. On that surveillance, the conviction was overturned. We're back at trial now. So I want to ask you, Gene, I'm going to start with you as a defense attorney. How are you going to decide if you proceed differently or in the same way that you proceeded at the first trial?
Well, the second trial, I'm not going to get into the relationship between the ex-prosecutor and the agent. That's just drama that doesn't need to be in a courtroom. Save that for another day. But I would pound and I would stress that video that was not disclosed. And as I understand, there's an unknown individual in the parking lot next to where she passed away. And it's right before the murder or hours before. And I would say, it's not my client, it's that guy. And the police have to be looking for that guy. So that would be a big reasonable doubt issue for me.
So it's going to be really interesting to see, and I appreciate that, Gene. But, you know, the defense did say in opening they've pointed the finger at her husband. So the picture you had just seen was Michelle Mockbee. That is the victim in the case. She was 42 years old. A horrific, brutal murder of her. He is now on a break for lunch. We are going to take a short break. Again, we're continuing to cover 3 different trials and some Millette, and we're going to have a special on that at 2 p.m. Come right back and tune in after this very short break on Law and Crime. Back to Law and Crime. I'm Judge Ashley Wilcott. All right, let's give you a recap of where we are in today's trials. I just mentioned Kentucky versus David Dooley. This is the one where the janitor's accused of murdering a 42-year-old woman, Michelle Mockbee, at her workplace. They are on a lunch break, so we will resume covering that trial when they come back from lunch. Next, we have Florida versus Russell Holbrook, and this is one that is on... right now there's a retired investigator on the stand, and they are playing audio statements that he took of the defendant when he interviewed them beginning on January 25th of 2006. Now, because they are playing the audio recordings in court, it is difficult to hear, so we're going to dip in and out of that, and we're certainly going to continue to keep you updated on that trial. The third that we're covering live is California versus Charles Merritt, the MCSTAY family murder case. This is one we've been covering for more than 20 days. Certainly you've probably heard of it, familiar with it, and it's expected to last for months. So we're going to start looking at this trial by having Aaron Keller's own summary to give us an excellent overview of where we are in this case.
How does this family of 4 disappear off the face of the earth?
California small business owner Joseph MCSTAY and his entire family disappeared February 4th, 2010. Their car was abandoned near the border. Authorities believed this video showed them fleeing to Mexico, presumably to avoid business debts. Case closed? Not even close. Fast forward more than 3 years to November 2013. A biker discovered the skull of one of the family members in the Mojave Desert.
I was traveling on a dirt road. I stumbled across the remains.
All 4 were buried nearby. Authorities arrested Chase Merritt, a business associate to Joseph MCSTAY. They believe he killed for money.
The why boils down to greed, and greed's child, fraud.
The defense says Merritt didn't do it.
Charles Merritt, which everybody calls Chase, that was his best friend.
The state has presented a $4,000 check from MCSTAY to Merritt, made out the day MCSTAY disappeared. But Merritt never cashed it. He told police there was always money and merchandise moving back and forth between him and MCSTAY, since they frequently did business together.
Someone calls you and indicates that they are Joseph MCSTAY.
Someone with at least some access to MCSTAY's business accounts tried to change his QuickBooks software right after MCSTAY vanished. The state also presented cell phone searches for information about the family's disappearance, made by Merritt, shortly after the family's bodies turned up in the desert. In those graves, a hammer prosecutors believe was the murder weapon. Also, shards of a bath mat. Authorities think it matches linens missing from the family's home.
They were beaten about the head and face until they died.
The family's home, prosecutors say, is the crime scene, but evidence is scant.
You will look for things, signs of violence, correct?
Yes.
And you didn't see any of them?
No, sir.
One officer who took photographs there realized back at the lab that she may have found blood on the family's table, but she didn't see it when she was in the house, and it was cleaned before anyone knew it was there.
When I saw it, I was horrified.
Why?
Because I thought it was something I missed.
The defense is pointing to an alternate suspect who also did business with the family and to unknown DNA found in the family's graves. This is Aaron Keller reporting for the Law and Crime Network.
Thank you, Aaron, for that great summary. Gentlemen, I'm going to bring you back in, Gene and Andrew, because here's where I want to go with this. We know that the forensic accountant has testified in this case. He's expected to be called for cross when we start today live with trial, but until they resume trial, he has testified that the bank account of the defendant throughout most of 2009 either had a zero balance or a negative balance. Andrew, let me start with you. So what? I understand that goes to motive, but how does that prove that this defendant killed this family?
Well, I've been very critical over the last few weeks of the fact that the amount of money the prosecution says that was the motive for this case isn't enough for the type of crime. But I'm going to go to the other side today and talk about the idea that money is always a motive. The idea that people are killed over $5 on the street. Money motivates crime. And so here, what the prosecution is really trying to do is they're trying to lay out the motive for why a crime of this nature would have occurred. If that amount of money meant something to Mr. Merritt, that would have motivated him potentially to commit the crime. Motive is key in any murder case.
All right, so Gene, I'm going to throw it to you now. You have the motive. There you have it. Now, your defense, what are the pieces of evidence that you've heard that you would say, who cares what the motive is? These pieces of evidence, as we know at this time, because they have many, many days to present more evidence, but as we know it at this time, as defense, these are the pieces of evidence that I'm going to rely on to show reasonable doubt.
Oh, boy. Well, the first big motive that reasonable doubt would be Dan Kavanaugh, all right? I know Dan Kavanaugh was in Hawaii, but Dan Kavanaugh easily could have hired somebody to do this. Second thing I would argue is there is no way in heck that one person killed these four individuals, the couple and the children, by themselves. It took 2, 3, maybe 4 people. 3, the different tire marks in the desert. 4, the photo of the couple and apparently the children walking across the border. 5, searches for passports and things on the internet before they were taken. 6, there is very little evidence of a struggle in the house. And if they're going to prove that the 4 victims were killed in the house, they don't have enough evidence to prove this. So there's reasonable doubt where the bodies were killed and taken. 7, the amount of money that is owed to the defendant is a crumb. It's a crumb. That's going to cause him to kill 4 people? I could get to 12, but I better stop.
All right, so let me ask you, though, Andrew, I'm going to throw it back at you to play devil's advocate. There may have been other people. All of the points Gene just said, not all, most of them go to the fact that it points to there being more than one person who committed this crime. But that doesn't mean that this defendant was not one of those, does it?
It doesn't. The prosecution in this case, I think in some regards, has overplayed their hand with the specificity of the theory that they have. For example, the idea that the crime happened in the home. Well, they're missing the sort of blood that you would expect. They're focusing in on these droplets of blood that are on a table that haven't been tested. That's a huge mistake for the prosecution to take that little bit of evidence and turn it into the theory of where the crime happened. You're absolutely right, Judge. The idea that the crime could have happened in any number of different places under different circumstances, I think the prosecution should have been a little bit more wide sweeping in the idea of where it could have happened or the circumstances that it could have happened in. But at the end of the day, we know that there's certain evidence that points directly at Charles Merritt to say that he was part of the overall murder here.
All right, so let's talk about, we're going to throw to a clip, but here's how I want to set it up. You both have referenced the family home where prosecution said this occurred. But there is evidence that's already been presented that the defendant was in their home after the murder. And what does that mean? Let's hear from, this was testimony by the victim's brother who went into the home with the defendant. Let's hear what he had to say.
He had a record. Does it? The defendant told you he didn't want to go in that house because he had a prior record.
Leading.
He had had some trouble with the law, and he didn't want to go in. I don't remember the exact wording, but
that's what the defendant told you?
If I said that, I remember it way better back then.
Okay. The defendant told you something along those lines of why you didn't want to go in the house.
Yes, sir.
You then relayed that to Detective Bachman in 2004.
Yes, sir.
There you have it, testimony directly from the brother that the defendant, in this case, Charles Merritt, said, I don't want to go in the house because I have a problem. We're going to resume testimony to find out what happened next right after this short break.